Your update on the stuff that's going on at Booker High School, as I said, with their scheme to steal the intellectual property and the rights from the students. There was a letter that was drafted December 19th by the district. It says December 19th, however, we received it on the first day that the students returned back to school after the new year. Okay, so we got it in 2020. This is dated on the 19th. Now, I want to read something to you that you'll find interesting. It says, dear students and parents, and I might paraphrase a little bit, but I'll make sure you get the gist so people don't say I'm hiding things, which I have nothing to hide. I've been honest with you, but we're going to find out some other people were not honest. And the proof is in the pudding, not just me talking. And it says, dear students and parents / guardians, after gathering input from stakeholders and consulting with the district and reflecting on the intended purpose of the work for hire agreement / assignment of copyright, a revised document has been created. Whoa! And is intended for use with collaborative school projects. The revised version of the document is more specific, removing reference to individual projects, but does not change the efforts to protect all students and their rights within a collaborative project, which is still laughable. Then it says contact me. The me on this one is Catherine Kokoza or Angela Harts-Vixen, fine art specialist, blah, 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 blah. If you have any questions regarding this agreement, then it says questions regarding the course should be directed to the Film and Animation Department Chair, Lori Burton. Then it says the good part on here is this little line right here. It says, and I quote, not paraphrasing, I quote, the original previously signed document will remain in place until a signed copy of the updated version is returned to Miss Burton. This is the new document. This is the new document. And I'm going to read that to you as well. I want you to pay close attention. At the bottom it says the original previously signed document will remain in place until a signed copy of the updated version is returned to Miss Burton. 1. How can something remain in place when you clearly stated that the intended purpose of the work for hire agreement / assignment of copyright, you were reflecting on the intended purpose, and then a revised document has been created and is intended for use with collaborative projects? The revised version of this document is more specific, removing reference to individual projects. So how can you still have that contradicting statement at the bottom? It says the original previously signed document will remain in place until a signed copy of the updated version is returned to Ms. Burton. That sounds like a authoritarian / dictatorship that we must live in, because you didn't get it out. They didn't say anything about signing or not signing, but I have a reason for that. Okay, make sure you pay attention. I have that reason. I'll just read you this little updated version of the work for hire / assignment of copyright as well. Just go through it, skim it. They just took out a few words and just changed a few words around. Pretty much still the same thing. You tell me what you think. Work for hire agreement / assignment of copyright for collaborative school projects. I blank ask consideration for participating in collaborative school projects with other students, volunteers, and or faculty at Booker High School agree that the works described below are works made for hire as defined by the copyright laws of the United States of America and School Board of Sarasota County, Florida, which is represented in here as schools again, shall own all rights, title, interest in the works. To the extent the works is not deemed works made for hire, I irrevocably assign and transfer to school and its affiliates and assign in perpetuity until death all right, title, and interest to the copyright in the works. And it goes to describe what the works means. Okay, this is getting redundant because it's the same thing. It says, works shall mean all photographs, videos, sound recordings, editings, artworks, designs, images, scripts, text, performances, and other pictorial, graphic, or audiovisual or parts of a motion picture, including any contributions, revisions, changes, or modifications related to the collaborative projects / assignments in the film and animation class at Booker High School. Then it goes on to say the work shall constitute school's property solely and completely. School may alter, enhance, modify, assign, transfer, or license the works at its sole discretion and for any and all purposes. School acknowledges that this release shall not apply to any projects that I am working on individually. Okay? Then it has parentheses, i.e., not in collaboration with others, close parentheses, or outside of those works identified above. Then it says, I agree to all this other kind of stuff. Now, two things that I found in here. How they worded this in, they said the work shall constitute, and it goes into all this stuff, shall be all this photographs, video, Then it says related to the collaborative projects / assignments, okay? This thing at the top says collaborative school projects. Down here now it has assignments in it. Assignments is what you do at work as a normal student. It doesn't have to be a project. It's normal work for an educational institution when a student is doing something and turning it in for a grade. That's an assignment. That's not a project. Now, this is where you try to be, again, word soup. Words do matter for every attorney. Words do matter for every person that signs any kind of binding agreement. I've stated this one time to all those parties that keep putting this stuff out. Words do matter. Also, one other thing that caught my attention, because I have an eye for contracts, because I've signed plenty contracts in my day, and I'm still doing so, but I won't sign this, nor should any parent. It says the school acknowledges that this release shall not apply to any projects that I am working on individually. Then it says, i.e., not in collaboration with others. You know, collaboration means more than one damn person. That's what collaboration means. So if myself and somebody else is doing something, but it's outside of school, that is still considered collaboration. I can do it with a student, but it's still considered collaboration. I can do it with a parent. What is a volunteer? Do you know how vague the term volunteer is? I can be a volunteer at the Red Cross. I can be a volunteer at the Coast Guard. I can be a volunteer at the pet shelter. But I can also be a pet owner. I can also be a veterinarian. I can also be all these other things as well. So a student can be a volunteer. A faculty member can be a volunteer. A parent can be a volunteer. So again, we playing word soup. And the reason why we playing word soup is because you have no basis to stand on. It was not your intent, but M.Hawthorne brought it to everybody's attention. Now it has been changed somewhat. So those that still want to talk from the outset, saying that I was incorrect and I was wrong about what I was talking about, actually I was not. So do your own research before you start talking to a professional. Okay? Do your own research before you start just talking. Talk to me with facts. Don't talk to me with assumptions or just because somebody's name is this and somebody's name is that. I don't care. I told everyone from the get-go I was only trying to help remedy this. And now I uncover so much more. So if anybody wants to talk to me, other than the disrespectful folks that decide to keep pushing this, I am willing to talk. If anybody wants to add anything to this or anything to what's going on, contact me. Because I'm not hiding. I don't have a cover up. I don't have a dog in the hunt. Because my son was actually, because we didn't sign the first one, which seems to be kind of like not really valid. My son was basically booted off the film project. And there's a lot more information to come with that I'm gonna keep to myself for a little while, or others that really need to know, because I actually uncovered the whole scheme. And I'm gonna share a little bit more with you. And how can this stay in place? How can the other one stay in place when they're two different contracts? Does that even make sense? Anybody that does contractual law or knows anything about contracts, there can be no two conflicting contracts. Again, it shows you the competency of the header right here. It says Sarasota County Schools. Again, when you try to lend a little bit of advice and you got somebody trying to run with something that is actually improper, it goes further and further, and it festers. It's like a disease. It starts over here, some kind of small, and then it starts to spread and spread and spread until it consumes you. Well, now there's a lot more people involved in this, and it sounds very incompetent on how this thing is now going. Incompetence breeds incompetence. That's all I can pretty much say, because that doesn't even make sense, saying the old one stays in effect until you sign the updated version. Well, what if they don't want to sign? Oh, I got that. It goes into the trustworthiness and the truthfulness of what I've been saying the entire time. You're not able to trust everybody. But let me proceed.